Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Kristine Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Kristine Cison.
Hi, everybody, and welcome to the August 2024 podcast episode of Third Fridays. My name is Kristine Cison, coming to you live from Lois Law Firm, and we have a very, very interesting episode for you today. Every August is the mock trial finals. It's always one of our most downloaded, listened to episodes of the year, and of course, every year is different. So we have our finalists from the mentor section of this year's mock trial program. So I'd like to welcome Meisha Powell, Anthony Iler, and Kristine Rosales to the show. Welcome, guys.
Hello.
Thanks for having us.
So I guess the way we can start this off, because our listeners probably know a preview of it based on an earlier episode we did with last year's champion, Ryan Wallace. What were your guys' first impressions of this year? You know, how did it go, for you? What were the challenges with this year's program? Anything that you can put together so that listeners understand what happened?
My first impression was it's going to be all simulating an actual hearing, but I was surprised that for this mock trial, we opened the mock trial with a debate on the amendment of Section 114, and we have different stakeholders present their opinions about what their stand is on the amendment of the Section 114, and everybody presented really great views. After that, we proceeded with the different prompts following the different stages of the trial, and the most important part was the innovation for this mock trial, where we had litigators and mentors. Last year, everybody just participated as litigators, but for this year, there are two different categories: mentors and litigator paralegals and litigator associates. For this year, it was really very exciting because I worked with various team members whom I didn't work with in the past. Last year, I worked with Anthony Iler, and I was really inspired by his taking on the role as a mentor when all of us were just litigators. And for this year, I mentored various paralegals, and I actually wanted to mention that two of my paralegal litigators are finalists, Michaela Cavanagh and James Milone. I also have another litigator mentee who is also a finalist. She's number 4, Alexis Sinchong.
Yeah, so Kristine, you mentioned Anthony there. Anthony, working with everybody as a litigator participant last year compared to the mentor role you had this year, where you weren't being the one, I don't want to say not participating, but you weren't the one on the stand. You weren't the one getting graded on your performance. It was your ideas and your collaboration with a group of litigators that are not as experienced as you are coming to light. How would you compare those two experiences? Which one was easier? Which one was harder?
Well, they're different challenges, obviously. I've been with the firm for a while. I've been doing workers' comp for a while, so I kind of, in a hearing or in the setting that we set up in mock trial, is where I'm comfortable, and then it's a different thing when you're prepping other people, some of which are non-attorneys or attorneys in other jurisdictions. The one thing I will say off the top, I'm blown away every single year we do mock trial. Our paralegals crush it. They're just so strong, and they're prepared, they're strong, and you would never know they didn't have a law degree when you watch them. But I think the last year, I don't know, I kind of feel like I almost kind of invented the mentor role, because last year I found myself in the mock trial and holding back because I wanted to let the other people kind of shine, because there's so many people with so much talent that I kind of was trying to set them up for success. And there was chances last year where maybe I could have, put the foot on the gas and just bulldoze through the entire thing. Not that everyone's, not capable, but I kind of tried to take a back seat and get the other people to shine. And I think that kind of segued into this year with the new format where, you're able to pour into the other people and really watch them grow and shine. And I kind of, being that that's what this is all about, I really like the way it was set up this year.
It's interesting. And, Meisha, you are participating in mock trial this year for the first time ever, right?
Actually, it's my second time.
Second time.
Yes.
All right. Well, I can't delete that out. So that's just going to run through. As someone who was, I guess in the throes of mock trial, and then in the middle of it, you received a promotion in the firm, like you're a senior associate now. Did that, I guess, how did mock trial like help, or did it add too much to, I think all the time about what people have to decide to do when mock trial comes up, right? Like, okay, mock trial is, it's not required, right? It's certainly voluntary. And there's always this innate pressure of, okay, it's another way for someone to see like if I'm good at what I'm doing, right? And there's that, like, I can totally understand if people don't want that, pressure, right? You, in the midst of going through a career promotion, did you feel any different about having to do mock trial in the middle of it? Or is there any advice you can give for people? Because, everybody wants to move up, right, the way that you did and then some. Is there any advice you can give to future participants as to what you went through?
Well, I have to say, when mock trial was introduced and the mentor role was put on the table, I was definitely interested. I was like, oh, wait a minute, mentor, like helping newer attorneys, newer paralegals, or just paralegals in general and attorneys in general, get a grasp of workers' comp, helping them through, the process. I love that because I feel like one of the reasons that I was promoted to senior associate is because of that exact role. Having people feel comfortable coming to me, asking me questions. That's a day-to-day thing. So when the mock trial came up and I'm like, okay, I'm doing this mentor role. I had a lot on my plate, but that's just what I was doing at the time. But what I loved about it was that I was able to work with other people in the firm that I've never worked with, just like hi-bye.
Yeah.
And I was so excited. If that, right? Because some are virtual, some are here. And I loved it. Some of the nerves, everyone was so nervous. I think that was the best part. So every single person was very nervous about the presentation for the mock trial. So I told them, I said, well, listen, everyone's nervous.
Yeah.
Right. Use that nervous energy. Right. And I kind of went into like, you have to portray confidence. Right. Because this is like you're going into an actual trial.
Right.
And as an attorney, a paralegal, like you have to give it your all. So I think one of the most important things that I try to, portray is that confidence that when you go in front of the judges, even if you're nervous, use the nervous energy to kind of, kick butt when you're in there.
Right.
And that was exciting. I really felt like some of the individuals that I mentored, when I watched it play out, I was like, oh, wow.
And you can see almost the nerves dissipate in real time and be the calming influence. Because we all go through it, like you said, right? I've been doing this like basically a third of my life at this point. And there's some hearings and phone calls and different things that we do in our daily life that I still feel it a little bit in there. I'm just like, ooh, like this is not going to be easy. And if it doesn't make you feel that way at some point, then it's not worth it, right? And so that's what I really like about this program is to what all you guys are saying, you get to see the future of this place like coming to light. And to hit the nail on the head, Anthony, right? Like our paralegals they crush it every single year, right? And it's always a surprise because we don't get to see them in court, right? We see our fellow attorneys in court. We talk shop with them all day. We talk about the judges. We talk about our adversaries and the cases and all that stuff. And so you can see that, but we don't see it so much with paralegals, and it's a very, very nice thing. So, we went through a gamut of different little tidbits there for all you guys listening at home. So as these three finalists are here, right, the competition is still going. So what we have for you is, I guess a 3-part final competition between Kristine, Anthony, and Meisha here. And the first phase of it is actually going to be something that we've never actually done before. He's almost just what are your ideas for mock trial 2025? And I thought that everybody presented in this room, some great little tidbits. So I want to start with you, Meisha, right? Because there was a wheel of doom. I don't know if that's my term. That's maybe my term that you created. Why don't you talk about that idea, what you would have for mock trial 2025?
Okay, so I have to tell you, unfortunately or fortunately, I take my work home to my kids, right? So I have 3 children. They're well aware that mommy's in this mock trial, right? So I go home. They don't really know what it is, but I'm like, okay, I have to come up with this idea, and these are kids, right? So they're like, Mom, why don't you create like a Wheel of Fortune type of thing where you spin a wheel and that determines, what you're going to do. So I'm like, oh, that's interesting. So, my wheels start to turn. Right. And I literally come up with this idea where you literally, if you picture the Wheel of Fortune, you literally have a wheel, and on the wheel are different types of trials, right? So you have ANCR, you have the pre-trial, you have a fraud trial, additional sites. And basically I was saying to make it very random, right? At the beginning of mock trial, you'll have the participants, once they're chosen, spin this wheel, and that will determine what your trial will be. So if you land on the ANCR trial, that's your trial. That's what you will be doing for mock trial. Yes, that is your topic.
And does that mean you're doing it for like the life of the whole season of mock trial? Like you're investigating, you're an ANCR trial participant, or are you doing that per prompt? Are you spinning the wheel every single month?
It would be one spin of the wheel.
Okay.
And that would be your trial, the ANCR trial, the fraud trial. And I felt, because even in this mock trial, the 2024 mock trial, I loved watching, the claimants counsel, defense counsel kind of going at it, making their arguments. So I thought that, hey, let's make mock trial 2025 about trials. And I felt the wheel would make it random. No one's going to say, why did I get the fraud trial the hardest thing,
Interesting.
to do.
Okay.
Yeah.
That's I really like the idea of not giving me the work to make the teams and right. Because that, if you just spin the wheel and that's what you're doing, that means like, okay, right. It's a little bit more up to chance, which is really exciting. Right. Amazing that your kids came up with it. Although I don't know, maybe we should give them the points. Right. Right. So we got the wheel. Anthony, your idea that you submitted was interesting, kind of harkened back to, a prior iteration of a mock trial season, right? What's really interesting is that it was born in like COVID, right? And we were on these Teams calls all day long. And your mock trial season, happened during the pandemic where everybody's at home. I actually specifically keep like my chair of the program plaque at home because that's where it happened, right? And all the other plaques are here in the office. So Anthony, why don't you go over what happened during that year that you thought would be a cool idea to bring back?
Yeah, I'll definitely get into that. But first, I want to lodge a formal protest. I also have 3 kids, and they helped me in no way, shape, or form. They were useless. Okay. One of them can't talk yet, so that's neither here nor there. So yeah, so my idea, the first year again, it was COVID, so we were, the world was a little different than it is now. But we had like a recorded after show, and I'm going to date myself. Like I associate it with like, after like Real World on MTV. For the new generation, it's probably Bachelor or something where they have the after show ceremony kind of thing where they go and talk shop about what happened. But on that after show that we had, it's the judges, a panel of judges would give person specific feedback and scoring. So it was entertaining, and it was also fun to see if you were going to get like name dropped or what they were going to say about you. But it would also allow people to get more specific insight to how they were being scored and how they did and what their strengths and weaknesses are. It's probably more work for everyone running mock trial, but it did bring an element of fun. And I think the positive and negative feedback is always beneficial.
Yeah, that was definitely, it brought back some memories when I got that submission, because we ended mock trial, and then the judges immediately went to like the after show or the post game show, or just imagine like you're just analyzing what just happened. And I thought, well, we don't get to share grades like in person. We're all separate. Let's just put our thoughts and record them, right? And use them to like give people some feedback, right? Because, it was just harder to do that in a group setting when everybody's at home, right? I mean, it's a little bit easier now because I think we're used to it, but right in the thick of it, it was harder. So, and then we would post it, right? So everybody would hear like, they name drop me, like Anthony mentioned, right? Or like, and we would actually vote on who won the prompts, like right then and there. So we'd say, okay, who is the paralegal that's winning this prompt? And then we actually have to say so-and-so. And so like it would be created in real time and just super gut feelings. So I think, that could be something that we could try to mix in. Kristine, you had a bunch of different ideas, right? I think the one that interested me the most was for the trivia aspect, right? So you had a couple of ideas, almost like hearkening, like Who Wants to Be a Millionaire, right? So
That's right.
What were your ideas for the trivia contest?
I love the classic idea about the trivia. And to make it more exciting and to encourage more participation, I envision its enhancement or further enhancement by the introduction of two lifelines, 50-50 and phone a friend. So for 50-50, there will be 4 answers. And then if the participant wanted to invoke the lifeline for 50-50, the 2 wrong answers will be taken out. And the 2 remaining right answers, the participant can choose from. And then for phone a friend, the participant will specify a specific person and with a phone number that the moderator could call if the participant wanted to invoke a lifeline to answer the trivia questions.
Yeah, that'd be certainly interesting, especially given my ineptitude with tech here, right? Like phone a friend, and then I have to call like, we're going to call Greg Lois and see if he's going to help out, because the participant wants to use Greg Lois as the phone a friend. You have Greg come on, and then I think that would be really interesting. So if I could increase my aptitude with technology, then I think that could be something that we could employ. But all really great ideas here. So we'll come back after the break to talk about phase 2. But phase 1 is over. Mock Trial 2025 with 3 great new ideas, and we'll be right back. Okay, and we're back with our attorney finalists, Brian Mooney, Natalia Verde, and Moshe Allweiss. Welcome to the show, guys. We talk a lot about how a case moves through from start to finish. And in mock trial, we had this situation where we go through an LWEC decision. And the next thing that I asked you guys to do was, from a neutral perspective, right, what is a number that both the claimant in our mock trial case and the defense in the mock trial case would walk away happy settling for, right? So in order to figure that out, you'd have to know, like, okay, what's my LWEC decision? What are my chances on appeal if I'm defense or claimant? And what's the number where we end up. So before we get into the analysis part of it, you guys have 3 different numbers, right? As you should. I'm going to get 9 different numbers, right, from everybody. So why don't we start there? What were your 3 numbers that you came up with? Anybody?
So my number that I came up with as a full and final settlement, Section 32 agreement, would be $175,000.
$175,000. Okay. Brian, what was yours?
200 plus MSA.
200,000 plus a Medicare set-aside allocation. And Natalia, what was your number?
$100,000.
$100,000, right? So, and the very interesting part of this is that even though the facts are the same, again, right? If I gave you better facts on impairment, better facts on functional capacity, vocational factors, and gave you so many different medical reports, I actually think that the numbers would be closer together. But this is the exciting part of it now, that everybody has a number that's different, right? So to get into the analysis part of it, anyone can start. We're hear from everybody. Why is your number what it is? You don't have to go through your whole thing, but give it some key facts, like 3 key facts. Why is your number? How did we get there?
We can start on the lower end. So
yeah, we'll start on the low side, 100,000.
Being in the mindset that I am as a defense attorney, for me, the big main facts were he's able to do his pre-injury job as a foreman. I think that was one of our key points in my own summation. The unreliability of the C4.3 as J severity ranking was just not adding up whatsoever. And then also just his the vocational factors and things that, his impairment was minimal. If he's able to play golf and, he was playing softball at some point before, for me, it was just like, this is so generous to give him $100,000.
You're saying that it's like you're on the low end. You're saying this is generous. So Brian, you were the highest one. You're the highest one, right? Like
by far.
You don't believe that the claimant would walk away with Natalia's number and be happy, right?
No, and listen, and I don't think they have a basis to. I think I said throughout mine, I really think the law judge had a fair decision based on the facts. I mean, in LWEC trials, I'm used to really bad numbers coming in, and then we're like, we'll appeal and it'll get knocked down. I think I went through it and I was like, I could see the board panel just punting on this and leaving it at the 40%. I actually went through it because Addison also breaks down what he associated each percentage to,
which you don't hear in any LWEC trial. When he was doing that, I was like,
which never happens. But actually, what he did benefits the claimant's appeal more than the carriers, because he gave a 10% to the permanent impairment and 15% to the other factors. But in reality, the 2A he found is probably like a 17% based on the impairment guidelines. So really, I thought on appeal, the claimant actually has a better position to argue for, say, a 47%, get that extra 7%. With this guy's earnings, and that would put him in a 25 weeks additional LWEC benefit, it increases exposure dramatically. My other thought was, when you're going through it as a carrier attorney and appealing this, really, like, you can't be mad about the 2A or the medium work capacity. I feel like those are good findings. So what are you complaining about? You're going to try to have them reduce to 15% on the vocational factors. Okay. And then I looked at it and said, best case scenario, maybe this gets chopped down to a 30, but it's very possible the board panel just punts on it. So I really looked at it as like, claimant appeal, best case scenario is like a 47% LWEC. And then I did carrier appeal, best case scenario is like a 30%. And then I think you could split those two, and that's like a 38.5% LWEC, which ends up being like a gross award of $215,000. That's indemnity only. I think if the carrier really won and got 30, there's still like $150,000 in an LWEC exposure there. So it's a high earning case, high AWW. There's no wiggling out of no LWEC here. A lot of money is probably going to be hanging over the carrier's head here. So that was really what my thoughts were. And I think it's very possible that the 40% would just stand, which moves well over 200 in the gross LWEC exposure. So that was my theory.
And then Moshe, right? So you're coming in the middle, but did you feel that your value was going to be primarily based on, Brian's position is saying that this might stand, right? Or the claimant might actually get a higher LWEC. How did you come to your number?
So my thought process was, if the 40% is appealed, which it would be on both sides, it could very well be, affirmed on appeal. I agree with Brian on that. However, how we were taught at Lois and how I think the world seems to be working in my, limited experience at this point, both sides appeal, but then they're going to settle in the interim because you're going to have to wait 6 to 8 months. And then there's still going to be, extra things going on, agreements, whatever. So they both appeal. They both set out their positions a little bit more specifically. And then the attorneys have a call and they say, let's settle. And truly, I think it would kind of be a split the difference in a way, like the $200,000, $220,000 for the 40% LWEC. And let's say 150, 145,000 for like a 30%, kind of split the difference right there. And you pretty much have your answer, which is what I anticipate happening in the negotiations between both sides.
Yeah, I kind of agree with everybody here in a weird way. Again, probably because I like the three different values, but mostly because you don't know really what the defense is going to be paying the claimant on appeal, right? So like, is the defense going to be pushing a fraud argument or an unrelated wage loss argument on appeal that would allow them to suspend benefits during the pendency of the appeal? And then what is the likelihood of that succeeding? And then moving to, okay, how much does this particular claimant need the money now versus I really like the back and forth that, if we're talking about new facts, right, just throw in any one of them, right? And then the numbers change again, right? So
yeah, there was also like an avenue in this case to actually raise like fraud on summations and get a decision on that, but that was never really fleshed out. So I kind of, you leave that out. I kind of went more so with what we had. I did note, I think in my review, that if the appellate positions were what their summation arguments were, I think the claimant was arguing for total industrial, and I think the carrier was arguing for like 10% LWEC.
Yeah, right.
If those were their positions on appeal, I think the board panel definitely would have maintained what the judge's discretion was, because I don't think those were in the real realms of possibilities. But
that's a good point too. I guess if you see the appeal briefs and you see that if the board panel is going to have to make a decision at either end of the spectrum and have it be more likely that they're coming here in the middle or just not making a decision at all, then it does give you a little bit more wiggle room. So now that you guys have heard each of the other person's numbers, what do you think about the support for those numbers? And, has that changed, or what do you guys have do you have any final thoughts as to what this number should settle at based on what you're hearing from your fellow finalists?
I mean, I'd be tempted to kind of stick with my number.
Yeah, you're not gonna change your answer on redirect, are you?
I don't think so.
I think Moshe's number's good. It's not far from mine. I just think he went strictly off LWEC, not.
Well, you're also asking for an MSA, right? So
yeah,
Natalia's going to go bonkers over that. That's going to be more than double her number already. But hey, I mean, the thing I love about the exposure that's outlined in the cases is that, when you're providing a value and then you're entering the negotiation, things can change on a dime, right? Like the response you get from your adversary can dictate how much you move up, if at all, right? So, Natalia might say to a client, hey, I want $100,000 to settle this case. They give her the $100,000. She makes an opening offer. The claimant says, I want $5 million. Well, it doesn't even matter then if the real value is 200 plus an MSA or 175 full and final, right? You just know that what you can do to dictate it. All right. Well, that was a great assessment from all of you guys. We'll be right back to discuss phase 3, which is trivia. Okay, we are back. This is the trivia phase of the mock trial finals. It's absolutely my favorite part of the entire season because it's such a great equalizer. So let's go over the rules. We have 3 finalists. Welcome to the show, guys. Karen Olarte, Michaela Cavanagh, and James Milone.
Hi.
Thank you for having us.
So you guys have really killed it all year, and trivia is going to include, really what's happened in the mock trial season, but also, to keeping in line with the subject matter theme, there are going to be some Medicare questions, right? So what we're going to do is ask you guys 2 questions each, and you will have the ability to answer them by yourselves if you want, in which case you can get the point value if you get it correctly. If you don't get it correctly and you're by yourself, the other 2 people have a chance to steal by getting the answer. So even though someone is going to answer the question individually, if that occurs, the other 2 people should be listening to determine, was that correct? If they don't think that's correct, then they should type in the answer, okay? I'll then call on the person who submits it first, and they can steal those points. The other option is anybody can choose to voluntarily involve the entire group for an all play. And so once I'm done asking the question, everybody can type their answer. That'll be the form of buzzing in. I will call on someone, whoever gets it first, and then we'll do it that way, where if someone gets it first and correct, they'll get double the points. Again, if they do get it incorrectly, then you have the option to steal whatever points are remaining. Partial credit is also given to certain types of questions. So for instance, let's say the question is, name the 10 things of the thing, whatever, right? And you only name 6 of them. So you'll get 60% of the point value, which means that 40% of the point value is left to be grabbed. Okay?
Mm-hmm.
Do you guys feel very confident?
Let's do this.
Sure.
Yeah, I'm ready.
Okay. All right. We're going to start with you, James.
Cool.
You can choose a 1, 3, or 5-point question, and you can choose whether you want to take it yourself or double the points potentially by involving everybody else. What would you like to do?
I'll do a 5-point question and take it alone.
Okay. Very, very targeted. Okay, so 5 points. There are 6 5-point questions. There are 6 questions in each bank. So which of the 6, 1 through 6, which one would you like?
Let's go number 1. This is as good as any.
Okay. All right. So basically in this question, right, you're going to get a reasonable amount of time. I don't have like an actual timer where I'm going to buzz you, but if I feel that you're kind of done, I'll cut you off and say, that's what your answer is, and it's over.
Now,
Okay.
I'm sorry if you explained this and I just completely glossed
Go
over
ahead.
it, but since I'm answering the question by myself, am I answering it verbally or am I still typing it in?
You're gonna answer it verbally,
Okay.
right? Since there's no like typing that I need to monitor, right? Okay. So the question is, 8 people played the role of trial judge this year. Name as many as you can.
All right. Tim Kaine,
That is 1.
Addison O'Donnell,
That's 2.
Declan Gurley,
That is not correct. Not correct. Trial judge.
trial judge. Jeremy Janis,
Nope, not correct. They all contributed, so thanks to them.
Tara Cullen,
Okay, that is correct.
Rose Stingo,
You have 4.
Brian Mooney.
You have 5. There are
Oh, what's her name?
3
Elizabeth. Elizabeth. I do know it. Give me a second.
Elizabeth David.
Yes.
She participated, but she didn't speak in that group, so she did not actually play the role of a trial judge.
Okay.
There are 3 more. 3 seconds. Just for dead air purposes, I have to keep talking. 2, 1.
That's it.
Okay, so you have 5 out of 8, so you get 62.5% of a 5-point value. The math of which I will do later, because I can't do it in my head. So Michaela and Karen, there are 3 other people that play the role of trial judge. Would you guys like to guess?
Yes.
Well, No. So Karen's bowing out. There are 3 people. Do you want to try and grab any of those points?
Joe Melchione.
No, that's incorrect.
Bradley.
Hames. Also incorrect. It's a tough one.
Elias.
No. All right. I think that that does it for that question. The answers were Chris Xyloportis, Julius Scarimbus, and Andrea Hales.
Would not have.
So the key was trial judge, right? Like the guest judges for mock trial. They weren't a trial judge, right? But they were a judge of mock trial.
Didn't I include like half of the guest judges in my answers?
You did.
Okay.
You did. That you got points for because Tim was also he was a guest judge and a trial judge. So you got points for Tim. Addison obviously was one as well.
Now, quick question.
Yeah.
I was going to say Kristine's paralegal because I know that Andrea is Kristine's paralegal. Would you have accepted that?
That's an interesting point. Like, do you get points for just naming like the person without their name? Given that they would hear this, I probably would be remiss in giving you points if they could possibly hear it. But hey, got to shoot for it, right? Okay, so let me just mark down for James. All right. So next we will go to, who's next? Karen. Okay. So would you like a 1, 3, or 5 point question? And would you like it by yourself or would you like more points for an all play?
I'll do a 5 point for myself.
Oh, another 5 for yourself. Question number 1 has been taken. So which of the following would you like, 2 through 6?
I'll do number 3.
Number 3, by yourself. Okay. How much consideration is needed for a Section 29 lien waiver for a Medicare set-aside allocation to be necessary for a Medicare recipient? How much consideration is needed for a Section 29 lien waiver for a Medicare set-aside allocation to be necessary for a Medicare recipient?
Are you looking for a value number?
I'm looking for an answer. I can't really give you more than that.
Okay. This was a mistake.
The 5 point questions are hard. It's okay. Would either the two of you, Michaela or James, would you like to answer?
Yes. Can you repeat the question?
If you could repeat the question.
Okay, so I'm going to repeat it for you guys. After I'm done, you have to type in to the chat your answer, and then I'll call on whoever comes in first. Okay? So the question is, how much consideration is needed for a Section 29 lien waiver for a Medicare set-aside allocation to be necessary for a Medicare recipient? It's like, James, you came in first, and Michaela came in second. With different answers, it's okay. They're both incorrect.
Okay.
James, your answer was
25,000.
25,000. Michaela's, yours was?
Mine was 250,000
Okay.
settlement.
Okay. So
No, I was freaking out because I'm like, okay, I was thinking
those numbers
250.
too.
Yes.
Why wouldn't you? Well, you should guess it though. You should always guess it.
I'd rather stay silent than embarrass myself.
Okay, it's okay. It was a very hard question, right? The reason why it's a 5 point question is because it's kind of a trick question, because if you are a Medicare recipient and you're closing with a full and final settlement,
anyway.
you need one anyway,
Yeah.
right? So the lien waiver could be 0, right? And you'd still need to consider Medicare's interests, right? So the answer to the question was none.
That's crazy.
That's actually very obvious once you say it.
Yeah. No, I agree. We
Right.
started talking.
I think like when you're hearing it, you're thinking like, oh, there must be a value. That's why you ask, Karen.
Right.
You're looking for a
That question was
value.
way
Well, what
too-
if I said no, I'm not looking for a value? What would I feel like that might give it away too, right?
Right.
Okay.
I swear, not last month, but last year when we did training on this, Declan asked this exact question and no one knew the answer, and he was like so disappointed.
Well, you guys are going to be closer to getting it. Okay. All right, Michaela, we're going to go to you for your round 1 question. 1, 3, or 5 point question. All play or by yourself?
Well, who am I to break a tradition?
Oh, wow.
I'll go for a 5-point question just for me.
Okay. So I had a feeling this would happen. That's why we have 6 of them just in case. So we did 1 and 3. That leaves 2, 4, 5, and 6.
I'll do 5.
5. Okay. Why is it valuable to have a Medicare set-aside allocation incorporated into the settlement of a third-party civil claim for the workers' compensation carrier?
Can you repeat the question one more time?
Sure. Why is it valuable to have a Medicare set-aside allocation incorporated into the settlement of a third-party civil claim? And why is it valuable for the workers' compensation carrier?
That would be helpful to the workers' compensation carrier because they will be able to recuperate a certain amount of money from the third party settlement. So the fact that they are including an allocation in that as well would mean that they would be able to recuperate more of the expenses that they put out in the workers' comp claim and whatever settlement they come to in the workers' comp side.
It's a really good answer. We're going to give you partial credit. We're going to give you 2.5 points for that. James and Karen, would you like to try and get the other part of it?
I would.
Can you repeat?
Yeah, so
Okay.
I'll repeat it once. Okay. Why is it valuable for the workers' compensation carrier to have the Medicare set-aside allocation incorporated into the settlement of a third-party civil claim? It's like those computer classes are coming in handy. James is furiously typing. Okay. So James, what did you answer?
So my answer is that rather than the third party carrier have to account for Medicare's interest and include that as part of their settlement, they're able to transfer that payment liability onto the defendant in the third party claim.
That is correct. So there were 2 parts to that answer. Michaela, you got the first one in the sense that the workers' compensation carrier will be able to recover more, right? If the MSA is potentially on the third-party settlement side, that increases the value of the third-party settlement, and that becomes recoverable by the workers' compensation carrier. The second part is, from James, is that we now don't have to deal with the costs and the time associated with procuring that Medicare set-aside. So they're very similar, but a little bit different. So you guys will share the points for that question. Good job. All right. That brings us to, it goes back to James, right, for the 2-point question, or the second round question, I should say. Let me just write it down. 2.5 for James and 2.5 for Michaela. James, your second round question, what would you like?
Let's just keep it rolling. 5 points by myself.
Oh, 5 points. I have a feeling we're not going to see any all plays here today, but that's okay. That's a good strategy if you want to keep it for yourself. We have questions 1, 3, and 5 gone. 2, 4, and 6 are on the board.
Let's go 4.
4. Okay. When is a 65-year-old individual not entitled to Medicare? When is a 65-year-old individual not entitled to Medicare? The part of it is that, I think age is typically a red flag, right? So age is a red flag. When is that basically not a red flag? 5 more seconds.
Christian, sorry.
Is it if they're entitled to if they're actively collecting Social Security disability?
That's a good try. They might still be entitled to Medicare, and that's why that's not necessarily correct. Michaela or Karen, would you guys like to try?
Yeah, I sent the message.
Oh, already
I don't know.
sent the
I
message.
don't know. That's
Okay, Karen, what was your answer?
my answer was even though they're 65, it doesn't mean that they're eligible. And if they have like no work history that's extensive or sufficient, applying to the
Right.
current claim.
We're going to accept that answer.
Yes.
Right? Okay, so
I'm on the board.
Michaela, your answer was also close. When they're less than 6 months from their paycheck, they could not be eligible for Medicare, but doesn't necessarily make them ineligible. And the reason that they may not be eligible is when you work for a job in the U.S., you're contributing taxes to Social Security, right? So the only way that Medicare should finance your medical needs is if you've actually contributed to the program. So you actually need 40 work quarters where you're working at a job where your taxes contribute to Social Security. So a lot of times, if you're not a U.S. citizen, you might not have that. And then if you are a U.S. citizen, but let's say you came over and you didn't work as much till you got to 65, or maybe you came over young and just didn't work, right? Mm-hmm. You're not going to be eligible for Medicare. Tough question. But Karen, you'll get the points for that.
1 point?
It was a 5-point question.
Okay.
So we'll go to you, Karen, for your second round question. There are 2 5-point questions left since you guys have been gobbling them up. And what would you like? 1, 3, or 5?
Okay, I'll stick with 5. I'm a little scared.
Okay, so 5 points. The questions left are 2 and 6, I think.
Okay, I'll do question number 2.
Question number 2. There's not going to be a lot of time given for this one, okay?
Okay.
Who played the role of the fictional claimant's supervisor this year?
Vanida Saunders?
That is incorrect.
Okay.
Do you guys want to steal?
What was the question?
Who played the role of the fictional claimant's supervisor this year?
Eunice.
That was the second one. So you guys both got it, right? But you're only going to get half credit.
Oh, okay.
So the reason why it's 5 is that 2 people played it. You have to say 2.
Oh, okay.
Right?
Well,
so Vandana played it in an earlier prompt, and then Eunice played it in the second prompt. So thanks to Vandana Saunders and Eunice Lim for their help with the program. So you guys will get 2.5 each. That brings us to Michaela for the last question of the trivia round. Where are we going to go?
I mean, it feels only right to take the last 5-point question. Blind pick, I guess.
Okay.
Not really a choice.
And are you going to go by yourself?
Oh, for sure.
Okay. Everybody's going by themselves. The battle lines are drawn. Okay. The question is, which type of set-aside projection or allocation has the highest risk level and which has the lowest risk level? Which type of set-aside projection or allocation has the highest risk level and which has the lowest risk level?
Can you repeat it one more time?
One more time.
One more time.
Which type of set-aside projection or allocation has the highest risk level and which has the lowest risk level?
So the highest risk level would be getting a official CMS approved MSA for a medical allocation, and the lowest would be incorporating Medicare's benefits into account and having the claimant do a voluntary set aside within the settlement agreement, and that would be based on the total of the settlement agreement and agreed to by both parties.
Okay, that's a good guess. That is incorrect. Do either of you guys?
Can you repeat, please?
So then this is going to be a typing one, right?
Yeah.
Once I'm done, you can type.
Right. Okay.
Which type of set-aside projection or allocation has the highest risk level and which has the lowest risk level? Okay, so Karen, what was your answer?
Okay, mine was a CMS approval with an annuity that is professionally administered.
And so James, your answer was just basically flip-flopping.
Flip-flopping it. A self-administered MSA would be the highest risk, and CMS approved is the lowest.
Okay, so I think both of you guys were like going down the same path. We don't have a correct answer here. the question dealt with the way the Medicare set aside was calculated, right? So if you remember, our highest risk is going to be in the form of a legal-based opinion or an evidence-based, where you're judging the future medical by saying, well, the claimant's not actually going to get this surgery because we have a good legal argument against it. It's unrelated, right? And so you're putting your legal opinion in there. The lowest risk is going to be your typical medical pricing reference guide, where you're going to take the doctor's reports and extrapolate it out. So what you guys went through was what you did with the MSA, or the terms for how to make it like stick.
Right.
What the question was asking, how is it going to be calculated, right? So if you're saying it based on, okay, you have a settlement of $200,000, let's just voluntarily allocate that. That has some high risk. So I do agree with you, James, on that front, but you're not actually inputting any evidence or legal theory into it. And so the way that it's structured, it's designed to tell you that if you want to advise a client to go with a legal or evidence-based submission, right, you actually get some higher risk of auditing in the future from the government. If you take the medical reports and extrapolate those costs out, it's always going to be very high, right? But the risk will be low that they'll come after you in the future. Does that make sense?
Yes.
Yep.
Okay. So you guys did such a great job. You really had the guts to go for all the 5-point questions. And typically they're just going to be hard. Just for fun, right? Like the 1-point questions were like, what was the claimant's name this year?
Okay.
Right. So they were going to be really easy. Right. And then the 3-point questions were kind of going to be in the middle, but you guys really went for it. So I appreciate that. I do actually have a few friends every year that listen to the podcast and they say, oh, I can't believe they didn't go for the hard questions. Like, come on, they got to go for it. So you guys really went for it. Congrats on an incredible year. And I look forward to announcing the winner at next month's firm anniversary party. So for Karen Olarte, Michaela Cavanagh, and James Milone, my name is Kristine, reminding you to defend from day one.